Good day everyone. I am Ken Asli Makalaba from BSc 3-2. Today, I will discuss arbitration agreement. But before we proceed, let's talk about the objectives of this topic. Objectives. At the end of the discussion, the student should 1. Understand the definition of arbitration agreement. 2. Analyze the kinds of arbitration agreement and the roles of arbitrators in resolving disputes. 3. Identify key elements of an effective arbitration agreement. 4. Learn how the arbitration agreement process works. 5. Note the advantages and disadvantages of arbitration agreement. Arbitration agreement. Here, it says that arbitration is a popular method of resolving disputes outside the regular court system. It is a form of alternative dispute resolution where parties agreed to let a private arbitrator to settle their disputes. The term arbitration comes from the Latin word arbitrary, which means to judge. In arbitration, instead of going to court, the parties present their case to an arbitrator, who makes a decision on the matter. Laws related to arbitration agreement. This law promotes the use of ADR methods like arbitration, mediation, and conciliation to solve disputes. The main goal of RA 9285 is to encourage people to settle conflicts outside of the courts, reducing the burden on the Philippine judicial system. Republic Act Number 876. This law provides a legal framework specifically for domestic arbitration in the Philippines. The primary goal of this law is to promote arbitration as an alternative to going to court for resolving disputes. It focuses on conflicts that arise from contracts and other agreements between parties within the country. Kinds of arbitration. Foreign or domestic arbitration. Foreign arbitration occurs when the parties involved in a dispute agree to conduct their arbitration proceedings in a country outside of the Philippines. For instance, if a Filipino company and a US firm enter into a contract that specifies arbitration in Singapore, that would be considered foreign arbitration. This type of arbitration allows parties to take advantage of legal frameworks and arbitration institutions in another country that may be more favorable to their situation. On the other hand, domestic arbitration takes place within the Philippines, where both parties agree to resolve their disputes in a location such as Manila or Cebu. An example of domestic arbitration could be a dispute between two local suppliers over a contract, which they choose to settle in arbitration venue in Quezon City. Voluntary or compulsory arbitration. Voluntary arbitration occurs when both parties in a dispute agree to resolve their issues through arbitration as outlined in their arbitration agreement. This means they willingly choose an impartial third person known as arbitrator to make a binding decision on the matter. For example, two business partners may decide to use voluntary arbitration to settle a disagreement over a profit distribution, reflecting their mutual desire to avoid court. In contrast, compulsory arbitration is a mandated by law, particularly for labor disputes, where parties must submit their case to arbitration without the option to refuse. An example of compulsory arbitration could be a disagreement between a company and its employees over working conditions, where the law requires both sides to resolve the disputes through arbitration to ensure fair treatment and avoid long court battles. Arbitrator. An arbitrator is a individual appointed to make a decision called an award in a dispute covered by an arbitration agreement. Unlike court hearings, arbitration panels are more private and informal, making them a less intimidating environment for the parties involved. Arbitrators often specialize in specific legal areas such as real estate or labor relations, bringing their expertise to their cases they handle. They can work alone or as a part of a group arbitrators, depending on the complexities of the disputes. Qualifications of arbitrators. This qualification of arbitrators are crucial to ensure a fair and impartial arbitration process. By requiring arbitrators to be Filipino citizens of legal age and in full enjoyment of his or her civil rights and other qualifications, the law ensures that they have a solid understanding of the legal framework and can act responsibly. Skills for arbitrators. Communication is essential for arbitrators as it allows them to explain complex laws and legal issues in a way that both parties can easily understand, fostering transparency and clarity. In negotiation, arbitrators utilize critical thinking and patience to facilitate negotiations between emotionally charged parties, helping them reach fair and satisfactory settlements. These negotiation skills also aid in strategizing effective solutions, minimizing misunderstandings, and ensuring that the arbitration process is constructive. Conflict resolution. Exceptional conflict resolution skills are imperative for arbitrators as they help navigate the legal disputes they encounter daily. By clarifying arguments and fostering open dialogue, arbitrators can guide parties towards mutually beneficial agreements that resolve their conflicts amicably. Key elements of an effective arbitration agreement. Award. Award is significant because it represents the arbitrator's resolution to the dispute between the parties, providing a binding decisions that both sides must adhere to. These decisions can be either partial or final, indicating whether it resolves all issues or only some aspects of the controversy. Ultimately, the award serves as a formal conclusion to the arbitration process. The complainant is crucial in the arbitration process as they initiate the dispute resolution by formally presenting their case. This party believes their rights have been infringed upon, seeking redress or compensation for the perceived injustice. By filing a complaint, the complainant sets the stage for the arbitration proceedings, allowing the issues to be examined and resolved by an arbitrator. The respondent plays an essential role in arbitration as the party responding to the claims made by the complainant. This individual or organization is tasked with addressing the accusations and presenting their defense, which is vital for a fair hearing. The respondent's participation ensures that both sides of the disputes are considered, allowing the arbitrator to make an informed and balanced decision. The venue of arbitration is a critical element in the arbitration process as it influences the convenience and accessibility for all parties involved. According to Section 30 of RA 9285, the parties have the autonomy to agree on the location, ensuring that they can choose a setting that is comfortable and practical for their circumstances. The language of arbitration is crucial because it ensures that all parties can fully understand the proceedings and communicate effectively throughout the process. By allowing the parties to agree on the language used, it accommodates their preferences and promotes clarity, which is essential for a fair arbitration. If no agreement is reached, the default languages specified English for international arbitration and either English or Filipino for domestic arbitration. Number of arbitrators in an arbitration agreement is important because it can significantly impact the efficiency and fairness of the arbitration process. In simpler disputes such as small claims case between two neighbors over property damage, having a sole arbitrator can expedite the resolution and reduce costs as there is only one decision maker involved. Panel of three arbitrators, also known as arbitral tribunal. In more complex cases such as corporate merging disputes involving substantial financial stakes, a panel of three arbitrators ensures that different perspectives are considered, as each party appoints one arbitrator And the third, who acts as the presiding arbitrator, brings the additional expertise and neutrality to the decision-making process. Arbitration process. The first step is initiated by the complainant, who feels wrong and seeks resolution through arbitration. This involves submitting a formal complaint that outlines the details of the dispute. Number two, after filing the complainant must inform the respondent about the arbitration process by issuing a notice. This notice serves as a formal communication that outlines the nature of the complaint. 3. The respondent must respond to the complaint within a specified time frame. Upon receiving the notice, the respondent is required to submit a formal response within a predetermined time frame, which is typically outlined in the notice. Therefore, once the complaint and response are filed, the next step involves selecting the arbitrators who will oversee the proceedings. The parties can mutually agree on a one or more arbitrators, often considering their expertise and experience in the relevant field. 5. After the selection of arbitrators, a preliminary hearing is often scheduled to set the groundwork for the arbitration process. During this hearing, the arbitrators, along with both parties, discuss and agree the procedures that will govern the arbitration. 6. Following the preliminary hearing, both parties are required to exchange relevant documents and evidences that they plan to use in the arbitration hearings. This exchange is critical as it promotes transparency and allows each side to understand the other's arguments and evidence better. 7. After the exchange of documents, formal hearings takes place, which are akin to court proceedings but generally less formal. During these hearings, both parties have the opportunity to present their arguments, call witnesses, and submit evidence to support their claims. 8. Once the hearings conclude, the arbitrators will engage in deliberation where they carefully review all the evidence and arguments presented during the proceedings. This deliberation process is vital as it allows the arbitration or arbitrators to consider all aspects of the case before making a decision. After a thorough consideration, the arbitrators will render an arbitral award, which serves as the final decision. Advantages of arbitration agreement. Neutrality of arbitrators plays a crucial in maintaining neutrality throughout the arbitration process. This means that they are expected to be impartial and not favor either party involved in the dispute. Privacy and confidentiality. One of the significant advantages of arbitration is its confidentiality. Unlike court proceedings, which are typically public, arbitration allows parties to keep the details of their dispute private. The speed of the disposition is often praised for its efficiency, as it typically leads to quicker resolutions of disputes compared to traditional court proceedings. Disadvantages of arbitration. No appeals. Decision made by the arbitration is considered final and binding. This means that once the arbitration award is issued, there is no formal process for either party to appeal the decision, regardless of whether they believe the outcome was unfair or unjust. Rules of evidence. In a traditional court setting, judges must adhere to specific rules of evidence that dictate what can be accepted during a trial. In contrast, arbitrators have the flexibility to utilize any information presented to them, regardless of whether it strictly conforms to conventional evidentiary rules. Not public. One of the defining characteristics of arbitration is confidentiality, which can be both advantage and disadvantage. While the private nature of arbitration protects sensitive information from becoming public, it can also create a lack of transparency that may disadvantage one of the parties involved. Overall, Alternative dispute resolution, especially arbitration, is a great help for resolving disputes without the need for time-consuming and costly legal proceedings. It allows both parties to agree in a decisions that will help them to resolve their disputes according to their needs. Arbitration agreement not only saves times and money of individuals, but especially it helps them to prevent congestion of cases in courts. I hope you gain new knowledge in our discussion for today. And always remember that knowledge is power.